on May 1st, it was reported that you had changed the Netflix profile names to communicate with Ms. Thompson and the children. Specifically, one profile name was changed to say, "You would leave me when I need you the most." Another profile name was changed, "Nathan, I miss you, son." Another profile name was changed, "Brianna, I miss you like crazy." Another profile name was changed to, "Is the ATT Hunter, I miss my minions." Another profile name was changed, "Sickness and in health, better or worse till ... That's one allegation. Wow, that was a very creative way to communicate with your family. I've not had that as a bond violation.
In this episode of F Around and Find Out, this defendant violates his bond conditions through Netflix. Let's get into the video.
In the matter of the state of Michigan versus Christopher Thompson, 23205. All right, we are on the record in the matter of the state of Michigan versus Christopher Thompson, 23205. And appearance for the people, please.
Good morning, Your Honor.
Okay.
Good morning, James Mikowski, P 62115, appearing again, Christopher Thompson, standing to my right. Sir, can you state your name and reference?
All right, thank you. All right, today is the date scheduled for a bond violation hearing whereby it's alleged that Mr. Thompson violated terms of bond by contacting the complaining witness and family members. The court will also note it's a review date regarding the referral to the Center for Forensic Psychiatry. So let me just clarify that one of the bond conditions are numerous, but specifically as it relates to the alleged violation, there's not to have or cause any third party to have any direct or indirect contact with following individuals: Susan Thompson and the children, N. Thompson, B. Thompson, M. West, and Blaze West, nor appear at the home in Riverview, the victim's place of employment, or the children's school. And according to the record, it's Nathan Thompson, Brianna Thompson, Music West, Brian West, and Blaze West. And there are allegations that there has been contact by Mr. Thompson with Ms. Thompson and the children. And so, we're proceeding with the hearing?
Yeah, Your Honor, at this time, my client is going to be guilty of violating his bond.
Okay. Mr. Thompson, please raise your right hand. You solemnly swear or the testimony about to give this be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. And add to the bond violation that you had contact with the protected persons, individuals you were not to have contact with. It's alleged to have been on 2 occasions. Let me just clarify, Mr. Kazak, there are 2 incidents. I know that there was a third at one point regarding a teddy bear, but that's not included in this violation, is it?
I think we just the 27th, Your Honor. I think it's 4/27/51 with 2 violation dates.
Right. I believe that we addressed the teddy bear last time, or some shirt or something. There was a shirt that was alleged to have been sent to something sent about, sorry, I'm an asshole, but I'm your asshole, or something like that.
That was a teddy bear, Your Honor.
So I wasn't losing my mind. It was a teddy bear, and that was addressed last time. That wasn't addressed as far as a violation. It was addressed as a firm reminder to your client to not have contact with the victims. I just wanted to confirm that that is not one of the 2 violations that are alleged. One of the 2 violations that are alleged, from what I recall reading in the motion, was the Netflix communication and a cup of some sort that was sent with a whole bunch of words on it. to Ms. Thompson. Is that correct?
Yes, Your Honor, yes, that's correct.
Is that your understanding as well?
Yes, Your Honor.
Okay. And sorry, I did just swear you in, correct? Did I just swear you in?
Yes, ma'am.
Yes, okay. All right, and sir, let me just clarify. So that we are all on the same page, that there are currently 2 bond violations alleged. The first one is that on May 1st, it was reported that you had changed the Netflix profile names to communicate with Ms. Thompson and the children. Specifically, one profile name was changed to say, "You would leave me when I need you the most." Another profile name was changed, "Nathan, I miss you, son." Another profile name was changed, "Brianna, I miss you like crazy." Another profile name was changed to, "Is the ATT Hunter, I miss my minions." Another profile name was changed, "Sickness and in health, better or worse till ... That's one allegation. As to that allegation, how do you plead?
Guilty, Your Honor.
Then there's another allegation that alleges that there is an Amazon package shipped to the home with your name on it, on the shipping label, and Susan opened the package with a card saying, "I'm so very sorry, I messed up big time. Please forgive me. I'm going through emotions, but I love you always and forever, from Chris Thompson." Further, there is an insulated travel coffee mug that says on it, "To my wife, I wish I could turn back the clock. I'd find you sooner and love you longer. I may not be your first date, your first kiss, or your first love. I just want to be your last everything. I love you forever and always, love, your husband." As well as an American flag with 2 people holding hands in a tree. As to that allegation, how do you plead?
Guilty, Your Honor.
You understand your rights, correct, sir?
Yes, ma'am.
And you understand that you have the right to have a contested hearing in this matter, and by entering into a plea, you will not have that contested hearing.
Yes, Your Honor.
And you understand the possible penalty as a result of your plea to this bond violation, these bond violations, correct?
Yes, Your Honor.
And specifically, you understand this court could revoke your bond, could incarcerate you, or a number of other alternatives. Do you understand that? Knowing all that, do you still want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
All right, and counsel, if you can please ready your client.
Your Honor, Thompson, did you in fact send that package to your wife at that time? I did. And did you in fact change those names on the Netflix account? Judge, for the record. I did. And did you know that you were under a bond violation where you can communicate with your wife and your children? Yes.
Okay, are the people satisfied?
Yes,
Court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the bond violations. And counsel?
Your Honor, first of all, I'd like to note that none of those, frankly, I got the notice of the bond violation last Friday. I called Mr. Thompson up, and I think it's pretty fair to say I screamed at him. Obviously, none of those communications were threatening in any way. His wife has subsequently filed for divorce. He was devastated by the filing for divorce. He was trying to make amends, if you will. he knows crystal clear now that he can have no contact. And the plain witness has been contacting his family and his mother where he's staying, has come by the house where he's staying, but he understands that just because she's contacting his family members, that does not give him a reciprocal right to contact them, because she's under no prohibitions to do so. He fully understands that now. As the court is aware, he was incarcerated for, I believe, over 60 days. He had a great union job. He just managed to get back to work at his place of employment on Tuesday. I submit to the court that incarcerating him again is not going to do anything good. It's not going to do his family any good because he's going, he has to support them financially still. I can't tell you how much I yelled at him for what he did. He understands he can't do it, and he's very remorseful. He had held up hope the marriage wasn't over, and now it's clear to him the marriage is over. Both parties need to move on. I would ask the court for mercy and do not incarcerate him again, and whatever other conditions that the court wants to impose, he's fully on board.
Mr. Gazak?
Your Honor, I would leave it in the court's discretion regarding how to address the bond violation. I would just ask, I think at the very least there needs to be some sort of consequence for violation, either an admonishment by the court with some form of penalty, either an increased bond or something like community service or some other sort of condition. Obviously, because this is multiple times, Your Honor, there is concern by the people that this will continue. But I think that the court discretion regarding how the exactly addresses the bond violation. And they were, to be fair to that's also references, they were non-threatening. However, I know there's certainly creates a huge amount of anxiety in playing. And so it certainly needs to stop. And so I would ask the court to hold some sort of accountability measures to address the violation.
Okay, so while perhaps 4 of the 5 messages were not threatening, reading the last message, sickness and in health, better or worse till ... that could be construed as threatening. While that was a very creative way to communicate with your family, I've not had that as a bond violation. That was a clear bond violation. This court gave you specific instructions after you sent the teddy bear not to have contact at all. And you couldn't follow the court's orders. I have zero confidence that you will follow the court's orders moving forward, because not only did you violate the bond by communicating with your family via Netflix, it wasn't just one time. You changed 4 profile names, one of which you changed twice. Or maybe you changed 5 profile names so that your wife could see the message twice. Then, I don't know if you saw that on TikTok, Instagram, Etsy, I don't know where you saw it, but you went ahead, you saw that message, you ordered a cup, had it all on there, and sent it with a card inside. 0 contact means 0 contact. And I'm very clear that I even said last time, which was April 6th, when we addressed the teddy bear. Don't send any packages. You still did it. You still did. And you went through the process of searching for something to order, ordering it, putting the words on the coffee mug. Then, once it arrived, You threw a card in there, or maybe you threw the card in there when you ordered it. I don't know. But you continued to contact your wife. You continued to contact your children. I don't doubt that it's a tough situation, sir. And as far as the complaining witness contacting your family, right, there's still children that are part of the family. I didn't hear any allegations she was contacting you. Contacting your family is potentially trying to maintain a relationship between your children and your family members. Because quite frankly, I'm sure your children have been thrown for a huge loop, and trying to maintain some normalcy with your family members is important. So the fact that Susan and the children may be contacting your family is not an invitation for you to contact her. And counsel, I don't know what other conditions I can put in place for your client to follow, because he can't follow this court's orders on multiple occasions.
Your Honor, I fully appreciate everything you said. I cannot agree with you more. One of the issues that my client is experiencing is, obviously, we have a referral for evaluation. When he was in Wayne County Jail, he was off medications he was on. They're just titrating his medications now. I don't know if that played some sort of role. He's been seeing a psychiatrist.
Excuse me, Judge. Please keep his voice up.
Oh,
I'm sorry. He's been seeing, if I need to repeat that, he's been seeing a psychiatrist. They're titrating his medications. And I think part of the issue was that it was a period when his medications were still being titrated. You know, I'm just begging you not to put him back in jail. That's just not the right resolution. I fully agree with you that his behavior has been atrocious with regard to following the court's orders. Fully agree with you. He is on a GPS tether. He has not gone to the house.
he doesn't need to. So he's communicating remotely, and he's signing in through Netflix and changing profile names to communicate with his family members.
I've never heard of something like that. Is you haven't. All I can say is it'll never happen again. I have read my client the riot act, and to put it very mild. He got more than your.
Well, the court gave him more than earful on April 6th, and yet he still violated this court's orders on a multitude of occasions.
And Your Honor, on April 6th, at that hearing, I believe he was still in Wayne County Jail, and medications were definitely not working.
Right, and then that date is when this court amended the bond.
I know. Again, Judge, I'm just begging you not to negotiate again. It's not going to do anybody any good. He's not going to provide for his family. He managed to keep his job by the skin of his teeth. He's working again.
Well, then your client knew exactly what was at stake. Knew exactly what was at stake. And I'm sorry, but this court's orders are the court's orders. The court's going to revoke your bond. You're going to be remanded to the Wayne County Jail today for violating this court's orders on a multitude of occasions. And that was the bond violation. As to the review counsel, have you heard, has your client been contacted by the Center for Forensic Psychiatry?
Yeah, the evaluation has been performed. We're still waiting on a report, Judge.
Okay, when was the evaluation?
When it was still in Wayne County Jail. It's been.
It's April.
I think it was. We thought we were going to have the report ready on the last court date, and we got a letter just prior to that court hearing that the report was not ready. They needed more time. I don't know what more time means.
Okay, let me just see here.
I've had no communication from them since that communication has been.
And I've gotten that, Your Honor, usually I'll get a copy of the report.
Okay, I'm sorry, I'm looking at the letter dated March 24th that we received March 29th. And the evaluation was conducted on March 24th. There was also a criminal responsibility evaluation that has not been done because there was a delay in that based upon the high volume of evaluation orders received by the center. So counsel, if you'd like to communicate or send a communication to a hospital director that sent this letter, which I believe you received a copy of, indicating that they can submit the competency to stand trial report first while they're pending the criminal responsibility, we can at least proceed that way.
I'm gonna pay this work. I don't normally do this. Did the court reconsider revoking the bond? That has GPS tether. Right now, it's just a location tether. You couldn't. The court changed it to a GPS tether where he can't, where he can just go back and forth to work, and even limited. Put an order out there saying he can't even use electronic devices except to contact the court.
Counsel, I can appreciate your zealous advocacy. I have zero trust for your client. The GPS tether will do nothing regarding the types of communication he has had. I don't trust that he's going to have zero access to an electronic device or communication device. Not only that, is he going to not watch TV too because you changed the Netflix password with a remote control? So I have zero trust that your client's going to follow this court's orders, as evidenced by his own behavior in complete and utter disregard for this court's orders. So I am not reconsidering. Bond is revoked. You are remanded without bond. You are not to contact any of your family members through any device, whether you have an opportunity to use the device within the Wayne County Jail or otherwise. Is that understood, sir? Because you said you understood last time, and look where you're ending up now. Because if you are contacting anybody while you're in the Wayne County Jail, I will make sure that you are in solitary confinement without any method of communication at all. We'll adjourn this matter for review to June 1st. So hopefully we'll at least have that report from on the competency at least until by June 1st.
Can we do that by Zoom?
Yes. And we can do that. What works for your calendar that day, counsel?
Whatever time it is.
Okay, let's do 9 a.m.
9 a.m. is fine.
Okay. We'll see you then. Thank you. We're going to be off the record for a moment. Has Miss
Hello, Judge. I believe Ms. Thomas.
Okay, just a moment. Let me. My court officers are a little bit busy right now, so just one moment.